Now is Aaron Hawley, Senior Counsel for the Alliance Defending Freedom. Aaron, welcome. Thank you so much for being with us today. First off, I'd like to get your take on how things went yesterday at the Supreme Court.
Absolutely. Well, I thought the argument in Dobbs could not have gone better. Mississippi's Attorney General and Solicitor General who argued did a fabulous job. And as we listened to the questions from the justices, I think court watchers were especially watching for Justice Kavanaugh and Justice Barrett as the new justices on the court, and also the Chief Justice. And both Justice Kavanaugh and Justice Barrett asked really tough questions of the other side. They indicated that they found it problematic that the court was involved in these sort of decisions when the Constitution is neutral. Justice Kavanaugh in particular was concerned that the court was getting into an area where the Constitution said nothing. So I think the argument went really well.
And Aaron, for you, anything that really struck out yesterday?
Again, I think to go back to Justice Kavanaugh, his questions were really piercing. He rebutted the assumption that the court should never overrule precedent. He listed a litany of cases, important cases, in which the Supreme Court has overruled prior precedent, including Brown versus Board, which many of us consider to be probably the greatest decision the Supreme Court ever issued. And so Justice Kavanaugh made the salient point that the Supreme Court does, in fact, overrule decisions. And sometimes those decisions that overrule prior cases become the most important that the court issues. So he made clear that he was not afraid to overrule cases, that he thought that is proper for the court to do. I also really loved the Chief Justice. He had some great questions pointing out that the viability line is totally unprincipled. It's unmoored from anything in the Constitution. And he noted that the United States laws on abortion are so permissive that it puts us in the same category as the People's Republic of China. Probably not a category we want to be in on a lot of issues, and certainly not abortion policy.
Yeah, definitely. And one of the things the pro-abortion attorneys argued that the 14th Amendment's due process clause, that is, grants women the liberty to have abortions. Can you talk to us more about that? And how does the liberty argument differ from other pro-abortion arguments, such as, the right to privacy?
Absolutely. That's a great question. And as you think about sort of the evolution of this abortion doctrine at the Supreme Court, it really illustrates just how made up the doctrine is. If you look at Roe, Roe famously, or I should say infamously, relied on the emanations and penumbras, as the court, they were quoting a case saying this, that comes out of the other Bill of Rights, which means they didn't find anything in the text of the Constitution itself. They sort of cobbled other interests together. Which is completely unprincipled as a constitutional matter, was widely derided even by liberal constitutional law scholars as not even constitutional law, nor even attempting to be. So the sort of attempt to resuscitate this doctrine has been to place the right to abortion in the Liberty Clause. And at least there is a textual hook. The 14th Amendment of the Constitution does protect liberty. But at the end of the day, this argument fares no better. And that's for the simple reason that in order for liberty interests to be protected under the 14th Amendment, the Supreme Court requires that right be deeply rooted in our nation's traditions and history. And if you look at the right to abortion in the 1868s, there absolutely was no right to abortion. In fact, most of the states limited, restricted, and forbid abortion. So there's just no way you can cobble together this idea that at the time of the 14th Amendment, there was a right to abortion. In fact, the opposite is true. And so the liberty argument fails as well.
Aaron, we have probably about a minute left or so, but wondering, ultimately, how do you think this is going to shape up? And also, what other cases do you have your eye on?
Absolutely. Well, this is, I think, a really encouraging oral argument. I think Mississippi is bold in asking the court to overrule Roe versus Wade and follow on cases like Casey. I think that's the most principled way for the court to decide the case. It would remove the court from an issue that constitutionally belongs to the people and return that matter to the states, which I think is the right thing to do, and also the sort of easiest decision to write because it's constitutionally accurate. The court could take a middle ground and uphold Mississippi's law. They'd have to distort their current doctrine to do that, but that too would be a step forward. So either of those would be a win, but I'm hoping for the big result here and returning the issue entirely to the states. And then one issue I would urge your viewers to look for next week is a case called Carson versus Mencken. It will be argued next Wednesday and is a fantastic school choice case in which the state of Maine, they have a lot of rural school districts, and some of those districts don't have high schools. So what Maine says is, well, we will help pay tuition at any school of your choosing. Some parents have sent their children to elite prep schools. There's even been a case of a student going overseas to school. But there's one qualification. Maine says you may not send your students to schools that are too religious, which makes no sense out of our free exercise clause. And I would be looking for the Supreme Court to reverse on that one.
Well, Erin, great to be with you. Thank you so much for your time and analysis. We really appreciate it.
Thanks for having me.